This is attorney Andrea Witt.
And I'm attorney Stephen Spano with a Legal and Financial Minute, or two.
Today, we're discussing an important topic that many people face after the passing of a loved one: inheriting a home that still has a mortgage on it.
Well, with the exception of a reverse mortgage, when you inherit a home with a standard mortgage, you have three options. First, keep the home and continue paying the mortgage. Second, sell the home and use the proceeds to pay off the mortgage. Or, well, the third option is just walk away and let the lender foreclose.
Let's dive into that first option, keeping the home. If you want to keep the inherited property, you'll need to continue making mortgage payments to avoid foreclosure. The good news is that federal law requires lenders to allow family members who inherit a home to assume the existing mortgage.
An oddly named law called the Garn-St-Germain Depository Institutions Act of 1982 prevents lenders from calling the loan due and forcing you to refinance at less than favorable terms. That law was further refined on July 8th of 2014 by the Consumer Financial Protection Bureau when it said that an heir can be added to a mortgage without even determining the heir's ability to repay the mortgage.
But before you add yourself to a mortgage, remember, while paying the mortgage doesn't mean you're personally liable for the debt, adding yourself to the mortgage may make you liable. Unless you become a signer on the mortgage, the lender can't come after you personally if you default, but they can foreclose on the home.
That brings us to option number two, selling the home. Well, if the mortgage is almost paid off and the home has increased significantly in value, selling could provide a very nice inheritance. On the other hand, if the home is underwater, which means more money is owed to the lender than the home is worth, then the difference may need to be paid off to the lender at closing, unless an agreement can be reached in advance with the lender.
The third option is to either just walk away or refuse the inheritance, letting the lender foreclose on the home. This may make sense if a lot more is owed to the lender on the home than it's worth, and you're confident that walking away will not have any impact on any other estate assets or the beneficiaries.
The right choice is very complex and depends on factors like the home's value, the size of the mortgage, the personal finances of the beneficiaries, and the sentimental attachment to the property. We absolutely recommend you not undertake this without consulting an expert elder and estate attorney to weigh your options.
Remember, inheriting a home with a mortgage is a complex situation with important financial and legal implications. Getting expert advice is crucial for making an informed decision.
Thank you for joining us. We look forward to sharing more practical, legal, and financial information with you in the future. Watch for our next episode of A Legal and Financial Minute, or two,
where we will continue to provide you with information to help you and those you love to protect your health, your assets, your income, and preserve your way of life.
If you have any questions or topics you'd like us to address, call or text Spano, DeWicki & Witt at 781-231-7800 or email us at help@spanodewicki.com. Thanks for joining us.